baravuza amafirimbi baterega nta kundi bati ngubu nyine n'ibyo byanyu byarangiye ni ugupfa nta kindi.
Tuza kugeza mbese nko mu masaha 3 z'amanywa.
Ha wundi muntu wundi.
UK residents can be prosecuted here if they committed any of these crimes after 2001. If committed before 2001, however, they cannot be prosecuted here for war crimes in civil wars, crimes against humanity, or genocide. The same loophole applies for non-UK residents visiting this country. They cannot be prosecuted here for committing any of these crimes, regardless of when they were committed.
There's a difference between the various international crimes which can be prosecuted here, which has come about as a result of the fact that the law on this has grown up completely piecemeal. Every time that there's an international convention, the UK has dealt with it by enacting a law. But as a result, it's a sort of mosaic.
One of those who have successfully been tried in the UK is Fayyadi Zardad, who lived in Streatham for years before he was found out. A BBC report revealed that Zardad had been a Mujahideen commander in Afghanistan in the 1990s. Travellers who passed his checkpoint had been robbed, tortured, murdered, or taken hostage until a ransom was paid. The Attorney General himself opened proceedings against Zardad in 2005. His explanation read,
"There are some crimes that are so heinous, such an affront to justice, that they can be tried in any country."
Zardad was sentenced to 20 years imprisonment for torture and hostage-taking. If his crime had been genocide, he could not have been convicted.
Someone who commits a sole act of torture could be prosecuted on the basis of universal jurisdiction, whereas someone who's committed horrific acts of genocide would not be subject to jurisdiction here, and there's little rational basis for that distinction.
4 Rwandans suspected of genocide have recently been arrested in Manchester, Bedford, Walton-on-the-Naze and Camden. All of them are accused of inciting people to kill Tutsi or of actively taking part in the killings. One of the suspects allegedly transported Hutu militia and grenades to Murambi School. In the massacre that followed, up to 50,000 people were killed. The 4 suspects are currently fighting their extradition, claiming that they will not receive a fair trial in Rwanda. There is a reasonable chance that their appeal will be granted. In that case, the 4 suspected genocidaires might not be tried at all, because the UK would not claim jurisdiction under the current legal framework.
I think there's a real danger that the jurisdictional gap represents an impunity gap. We need to avoid a position where there are people guilty of the most appalling war crimes living in our country without any risk of deportation or prosecution.
Aegis is asking Parliament to create a specialist war crimes unit, allow prosecution of any suspects present in the UK, make the law retrospective.
So we need to fill in these gaps in the law, but we also need to make sure that the law has some teeth by giving more resources to the police and to the prosecutors, perhaps through establishing a specialist war crimes unit.
The UK used to have a war crimes unit until 1999. It operated under the War Crimes Act. Lord Carlisle was one of the parliamentarians who initiated this act.
Well, the legislation allowed for the prosecution, retrospectively, of war crimes committed during the Nazi period. A unit was set up at New Scotland Yard. They started to investigate war crimes. I do not see why a Rwandan war criminal should not be prosecuted by exactly the same token as was used for prosecuting a Nazi war criminal.
The UK wouldn't be the first to set up a specialist war crimes unit. It'd be following the footsteps of Canada, Norway, Sweden, the Netherlands, Belgium, and France is about to.
Prosecuting any suspects who are present, not only those who are resident in the UK.
One of the problems we have with the present law is that in order to prosecute certain categories of offence, we have to prove residence rather than presence. Now, in law, residence is a slightly elastic concept, and it can be difficult to prove.
I do not think the distinction should remain between residence and presence. There should be no resting place for war criminals if the evidence is available against them.
And I think one of the simple reforms we could make in this area is to introduce some sort of presence requirement for prosecution rather than a residence requirement.
Making the law retrospective to allow prosecution for crimes committed before 2001.
If it's clear that a particular crime was criminal under the law of nations, under customary international law as of a certain date, then I don't see any problem, and there isn't any problem under Strasbourg case law in prosecuting people for those crimes.
Murder is murder, mass murder is mass murder, a war crime is a war crime, and I cannot see any empirical argument against retrospectivity for the prosecution of war crimes.
The current law allows many kinds of war criminals to live freely in our country, safe in the knowledge that they will not be prosecuted here. Parliament will have to decide whether it's our responsibility to change this situation.
I would support amending the law of the United Kingdom to prosecute anyone present in the United Kingdom against whom it can be shown that they were guilty of war crimes, genocide, or crimes against humanity.
Parliamentarians will have to decide whether they regard this as a sufficient priority. The price of not acting, of course, is that we have mass murderers potentially living freely in our country. People have to ask themselves whether that's acceptable.